For a long time now, I've been fascinated with the cake question. Most commonly, and in the case decided this week, a gay couple walks into a bakery and asks the baker to make them a cake for their wedding. The baker refuses on account of his religious objection to gay marriage, and a fight ensues over whether the baker ought to be forced by the state to provide his goods or services against his will. It's a fascinating question, not because of anything special about bakeries or gay weddings. It's a dilemma that strikes at the heart of serious cultural divides in this country, raising questions about fundamental speech rights, association rights, and property rights that form our foundational legal and cultural values. When I last discussed this particular case out of Colorado, I was frustrated by the arguments presented by this baker's legal team. My view on this issue is straightforward. Nobody owns your property or your labor but you. Not the government, not business, and certainly not a pitchfork mob of grievance mongers. The only way your labor and your property can be exchanged justly is on terms to which you agree. Voluntary exchange is what makes a transaction justified. Thus, I will defend any business's right to refuse to serve any customer for any reason, just as I will defend any consumer's right to refuse to support any business for any reason. And we'll let the market sort out the bad actors as it naturally will. But that's not the case this baker's legal team made. Instead, they argued that because this was a specifically religious conviction held by the baker, and because his cakes amount to speech, the state of Colorado forcing him to make artisan cakes against his religious views amounted to unconstitutional compelled speech in violation of his First Amendment rights to the free exercise of religion and to speech itself. The baker spoke to this issue on Tuesday Morning News.
Cakes have a message, and this is one that I can't create.
And I can understand why the baker's legal team went with this direction. They're trying to win their own case on as narrow terms as possible without calling into question decades of civil rights law. And I acknowledge that my own perspective does exactly that. I don't deny it. I think those laws as they apply to private business are philosophically wrong and constitutionally suspect. But that's a question the baker's lawyers chose to avoid. It's one that was obviously very important to the justices, as questioned by Justice Breyer during the oral argumentation.
Now, the reason we're asking these questions is because obviously we would want some kind of distinction that will not undermine every civil rights law from the year 2, including the African Americans, including the Hispanic Americans, including everybody who has been discriminated against.
My problems with the approach the baker's legal team took are two. First, you end up in the weeds of trying to differentiate what counts as a sincerely held religious belief. You have to explain why religious beliefs should receive more constitutional protection than just any old belief generally. And second, if cake baking itself is speech, isn't any job speech? It's a question the baker's lawyer fumbled on during the oral argumentation, when she clumsily argued that baking a cake for a wedding is constitutionally protected speech, but the hair or makeup work for the same wedding are not.
Who else speaks at a wedding?
The artist speaks, Justice Ginsburg. It's as much Mr. Phillips' speech as it would be the couple's.
Who else, then? Who else is an artist? Say the person who does floral arranging, owns a floral shop.
If they are custom designed arrangements and they're being forced to create artistic expression, which this court determines is a message.
So the jeweler?
It would depend on the context, as all free speech cases depend on. What is the jeweler asked to do?
The hairstylist?
Absolutely not. There's no expression or protected speech in that kind of context. But what it would
Well, why is there no speech in creating a wonderful hairdo?
Well, it may be artistic, it may be creative, but what the court asks when there's...
The makeup artist?
No. What the court would ask...
Quote an artist, the makeup artist.
I think that's a weaker argument than the one I explained previously, but I understand the practical effect the baker's lawyers are going for. Since that argumentation in December, I've been very eager to see how the court would decide this case. Would the court buy that compelled speech argument? Or would the court say that the state can enter your place of business and tell you how your labor and your property must be distributed, regardless of your will? Well, on Monday, we got our answer, and that answer is really neither. It was a 7-2 decision in favor of the baker, which on a surface level looks like a win for liberty advocates. But when you actually read the majority opinion from Justice Kennedy, it's even more confusing and jumbled than the baker's lawyers' arguments were in the first place. In deciding in favor of the baker, what Justice Kennedy actually takes issue with is the conduct of the Colorado Civil Rights Commission, the state agency that found Jack Phillips, the cake baker in this case, in violation of Colorado civil rights law. Kennedy notes the First Amendment requires any state actor to enforce its rules in religiously neutral ways. Anything else would be a violation of the First Amendment's free exercise clause. Writes Kennedy, the neutral and respectful consideration to which the baker was entitled was compromised here. The Colorado Civil Rights Commission's treatment of his case has some elements of a clear and impermissible hostility toward the sincere religious beliefs that motivate his objection. So it's not that the state of Colorado is wrong necessarily, at least according to Kennedy. It's just that they weren't nice and respectful enough in considering the baker's religious beliefs. And we know they weren't nice because Kennedy took a look at the commission's hearings considering the baker's case. At one meeting in May 2014, commissioners endorsed the view that religious beliefs cannot legitimately be carried into the public sphere or commercial domain, implying that religious beliefs and persons are less than fully welcome in Colorado's business community. Then in July, one commissioner said that religion has historically been used to justify slavery, the Holocaust, and other atrocities, and said religion used to hurt others is one of the most despicable pieces of rhetoric that one can use. In Kennedy's view, that comment is disparaging to the baker's religion, both because it described his views as despicable and reduces them to mere rhetoric, something insubstantial or even insincere. Kennedy writes there were no objections to these comments at these meetings, and the state court's ruling did not even mention these comments in its decision. Kennedy also notes there were at least 3 other cases where the Colorado Civil Rights Commission considered refusals of other bakers to create cakes with images that conveyed disapproval of same-sex marriage along with religious texts. And in those cases, the commission sided with the bakers, finding those bakers acted lawfully in refusing service. For these reasons, Kennedy writes, the court cannot avoid the conclusion that these factors cast doubt on the fairness and impartiality of the commission's adjudication of this baker's case. Therefore, the state court's decision is reversed, and the case is decided in the baker's favor. So in other words, the court doesn't take issue with the state of Colorado's law or the state of Colorado's punishment of this baker per se. The court only takes issue with the state of Colorado's process in this one particular case. The idea here is that the only problem in this case is the state of Colorado wasn't respectful enough of this baker's religious beliefs, but there are serious implied problems within that conclusion. It implies at least 2 things. First, that the state of Colorado's punishment of this baker would have been constitutional and just if the state had simply been more respectful of his beliefs in the process. And 2, the implication that the only reason this baker's beliefs were deserving of so much respect is because they were religious in nature. What if this baker opposed gay marriage not for religious reasons, but let's say for biological reasons? Let's say he opposes gay marriage because he believes homosexuality is biologically unnatural. In that case, would the state of Colorado then be justified in punishing him and forcing him to bake a cake? This decision implies yes. Ultimately, what we're left with is a ruling that is entirely specific to this one particular case and the conduct of this specific state commission in Colorado, with the implication that if the Colorado Civil Rights Commission had simply conducted itself more fairly in the subjective judgment of Justice Kennedy, if it had simply respected the beliefs of this baker just a little bit more, that the outcome they reached would have actually been fine. What we're left with is a really flimsy and technical reason the court is giving this one particular baker a break, with no precedent for liberty set for future bakers or business operators of any kind with a similar situation. While it's nice to see this one baker win justice, this is a momentary victory on technicality, not a broad victory with principle and precedent. And there is reason to have concern that lack of firm precedent for liberty will be consequential in the future. There's a nearly identical case of a florist in Washington state that could see its day before the Supreme Court justices, and unfortunately, this week's ruling gives no precedent of protection for the free speech, free association, and property rights of this woman. Freedom lives to fight another day after this decision, but it hasn't secured a future. I don't want to be too pessimistic about this case. I'd certainly rather see the baker win than lose on any any terms, even terms with which I disagree or terms I don't think are strong enough. I just hope that advocates for liberty don't see this case as a complete win, because it isn't, and there's a lot more work to be done to preserve the foundational values that are at stake in these cases. I want a future decision that makes it clear. You have a right to your own speech. You have a right to your own association. You have a right to your own property and labor. And nobody can take those things from you unless you agree to exchange them. Not the state, not business, not pitchfork mobs, and certainly not Justice Kennedy's feelings about being sufficiently respectful and nice. Here's hoping. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on Twitter. That is at ML Christiansen. You're always welcome to come hang out and chat in my live streams. Those are linked down in the description. Looking forward to it. Goodbye.